So welcome to the fifth session in our Law Practice Management Speaker Series hosted by LCL Mass LOMAP and the Hampshire County Bar Association. LCL provides free and confidential services to the Massachusetts legal community for mental health and well-being consultations, clinical evaluations and referrals, to practice management consultations and resources through our Massachusetts Law Office Management Assistance Program, known as LOMAP. Today's topic is billing best practices with James Barron, who I'll introduce momentarily. I just want to remind you that next week will be our final session in the series. The topic there will be benefits of law practice management software, which will be presented by Laura Keeler, Mass LOMAP Practice Advisor. She has hosted our previous session and regrets missing today's, but is hosting a solo and small firm meetup for the ABA Tech Show, where she's getting even more great info and insight to share with you all. We've been recording this series, so if you haven't seen or can't find them, those recordings, just let me know in the chat and we'll send you those links. And then also please use the chat to submit any questions during the presentation. And then after the presentation's over, if you've got questions, you can also unmute yourself or use the raise hand feature. Now I have the privilege of introducing James Barron. James is a solo attorney. He's a member of the bar in Massachusetts, New Hampshire, and Florida, as well as the United States District Courts in Massachusetts and New Hampshire. Mr. Barron handles a wide variety of education-related legal matters, ranging from special education to discipline to disputes involving college and university students. He has presented on special education issues for MCLE, Massachusetts Advocates for Children, the Federation for Children with Special Needs, and the Asperger's Association of New England. Mr. Barron has also presented on the topic of running your own special education law practice at the 2014 and 2015 annual conference of the Council of Parent Attorneys and Advocates, COPA. He has also presented on using technology to handle student records and gain the edge from intake through hearing at the 2017 and 2018 COPA conferences. Mr. Barron has served as guardian ad litem education advocate for the Massachusetts Juvenile Court. He's also served on the board of directors for the Greater Waltham ARC and the Waltham Community Foundation. As a member of the Law Review at Suffolk Law School, Mr. Barron published an article entitled "When Good Intentions Go Bad, the MCAS Graduation Requirement and Special Education Children." Mr. Barron was selected as a Super Lawyers Rising Star in the area of school law for the years 2011 through 2017. Mr. Barron has been running his own law practice since passing the bar in 2007. He's a co-founder, past board member, past vice president, and past president of Starting Out Solo, a group whose mission is to provide support, education, mentoring, and networking to lawyers who started their own law practices as a first legal career step out of law school. Mr. Barron earned a Bachelor of Arts degree from Brandeis University, a master's degree in education from Emmanuel College, where he also earned a Massachusetts teaching certification, and a law degree from Suffolk University Law School. Over to you, James.
Okay, thanks very much, Rachel. And so yeah, I'll be talking about billing and some best practices with billing. And if you have questions, feel free to stop me as we're going through it, and I'll be happy to address questions as we're going through. If it looks like time is running tight, we may have to hold questions to the end, but for now, I think we can plan to take questions as we go along. So Rachel, the time frame on this is about 45 minutes to an hour, is that right?
Correct.
Okay, all right, good. Okay, so what will we be talking about? Within the overall category of billing, there are a bunch of subcategories that we really need to look at. And it all starts with client selection, making sure that you choose the right client, a client that hopefully you'll be able to bill and get paid with. We'll look at the initial consultation and whether you should bill for that. We'll look at the fee agreement or the letter of engagement in terms of some billing matters that are in the fee agreement. We'll talk about types of engagement and how billing will work depending on how what kind of engagement you have with the client. Is it hourly or flat fee, contingency, or some sort of hybrid model? Then we'll talk also about what you can bill for and what you really should not bill for. How to track your time. We'll look at details about the invoice, and we'll talk about how to get paid once the invoice has gone out and it's time to get paid. And we'll also be looking at how to handle disputes. So I'm not going to do a formal poll here, but think a little bit about tracking your time and whether you really love doing it or hate doing it. Most likely, you are probably in the area of hate it. Very few people, attorneys, like tracking their time. Oftentimes, you completely forget to track your time until afterwards, and you realize, oh boy, now, now what? I think I've spent the last hour or two working on something, and I forgot to write down the exact starting time. So it's an important thing to do, um, but it's something that is just it's not you know, billing is probably the least favorite part of practicing law for me. Other than of course getting paid, but tracking your time and sending out invoices and trying to collect money and trying to keep your clients happy is it's a burden. Um, LexisNexis has done a survey of lawyers and has found that lawyers lose about 40% of their billable hours due to poor time tracking. And, that to me sounds fairly reasonable that, when I think about my own time, um, sometimes I purposely don't track every second that I'm spending on a client matter. But more, sometimes I really do realize after the fact that, oh, I probably should have charged for something or tracked the time and I didn't do it. So let's talk about client selection. Choose wisely because you're, um, when you get a client that makes your life difficult or makes your practice difficult, it can really wear on you mentally, emotionally. You want to avoid the caffeine replacement client, that client that is going to keep you up at night, the client that, when you stare at the ceiling at 2 or 3 in the morning, you're thinking to yourself, oh, why did I take that client? I knew I shouldn't have done that. And I think, if you've been practicing for a while, probably everybody has had that experience where you realize that, there's a client that is just, it's the client is causing you a lot of stress. And no matter what you can bill for that client, if you're losing sleep at night, it's not worth whatever you can earn. So choose wisely to avoid that. One thing you can do to avoid that is be upfront and honest about your fees. I usually tell clients with our very first phone call or consultation what the fees are, the hourly rate, or if it's a flat fee, what the flat fee will be. I talk about what the retainer is. I talk about what they should expect for the first month's invoice. And again, for me, as Rachel was talking about, I do education law. So oftentimes, the very first thing I need to do is a record review. Parents will come in, I will tell them what records I need, and I'll spend a significant amount of time, maybe 5 to 10 hours of time reviewing records, and that is billable. So I track that, and I warn them right up front that I'll be doing a record review. I'll be tracking my time. You'll see that on the first month's invoice, and multiplied by my hourly rate, approximately what you'll see on the invoice is X amount of dollars. And by being honest and upfront early, there is the chance that I've lost. In fact, I know that I've lost clients who realize that they can't afford it or that it will create too much of a financial burden. And as much as I don't want that to happen, I would rather have that happen than to have someone who can't afford it commit and get into it with my representation and then receive an invoice and realize that they made a mistake and they either cannot afford it or they're going to have a pretty bad financial burden themselves because of the legal expenses that they've incurred. I would rather tell them right up front what it's going to cost, and if I lose the client because of that, then I lose them. But I think that they appreciate the honesty up front rather than finding out later how expensive something will be when they didn't expect it. So the initial consultation, the client calls me up, and now of course the initial consultations are online, but whether it's online or in person, do you charge for it? Do I charge for it? And the answer is generally yes, I do. But you need to think about the type of law that you practice, what the competition is doing and what other lawyers are doing in your area, how much benefit the person gets from that consultation. Is it a quick 10-minute meeting and they sign on? Or have you spent a half hour or an hour talking to the client and they walk away with great information and you don't get anything? So, I look at when people contact me for representation, sometimes they'll say, I've got a quick question. And, if they have just a quick question, then sometimes I'll just talk to them quickly. But usually when someone says they have a quick question, it's not a quick question. Or if the question is quick, the answer may not be so quick. But there are people out there who really just want to speak quickly with a lawyer. There are people out there who are really looking for a one-time consultation. They don't want to hire a lawyer. They don't want to commit. They don't want a lawyer to engage for them. They just need to ask several questions, or they want to go over a situation with a lawyer. Sometimes I'll get calls from people that they were at a school meeting and they're angry. They're upset about something that has happened. Gosh darn it, they're going to talk to a lawyer. So sometimes they want to do that. Then there are people who really do want to hire a lawyer. And of course, there are the tire kickers that are just talking to lots of lawyers, trying to see who they're most comfortable with, what the costs are, and so on. So what I've done is I've set up multiple options for clients. And in fact, I'll jump into my website right now to show you how I've set this up for initial consultations. Let me share this window. All right, so you should see my website right now on the screen. If you do not, could someone please let me know so that I can try and fix that? But hopefully you're seeing my website.
We do.
And you can, I'm sorry?
We can see it.
Okay, good, thank you. And on my website, right in the middle, at the top, I've put a button for them to schedule a call or a meeting with me. So whether they've come to me because they've Googled me or they've been referred to my website, I click on schedule a call or meeting. And in fact, when they call my number, there's my voice message. Tells them, if you want to set up a consultation, please go to my website and select this button. So the way I've set it up, by the way, let me take a step back. This is through Calendly. It's up at the top here, calendly.com. So with Calendly, it syncs up with my, I keep my calendar in Google, and it will sync up with Google Calendar, or it syncs up with, I think, just about every major calendar package that's out there. And so it knows when I'm busy and when I'm available. And one option that I have is for a brief 30-minute consultation. So if somebody wants to consult with me, they can click on this button. And the next screen will show the days and times that I'm available, or at least the days right now. And you can see that I do charge for that 30-minute consultation. I charge $30 for a 30-minute consult. And what the person would do is they would choose the date that they want to select something. Once they click on it, the times pop up. They can select the time that they want the meeting, confirm that. And now we're at the screen where they would enter details. And again, I'm hoping that you're seeing this, and I'm assuming you are. If you're not, please let me know. So they will enter their name, email address. They'll choose how they want to meet with me. Do they want to use GoToMeeting, which is what I use? It's very much like Zoom. Or do they want just a phone call? They should share some information. And I'm not going to go through every step here, but I prompt them for information that I need. Then at the end, down at the bottom, notice that there's a button, click with PayPal, or pay with PayPal. So they can click that button and it brings them into PayPal and they can charge it to their credit card. So I bill for it right up front. They don't pay at the time of the consult. They pay when they've actually scheduled this. If they cancel before the meeting, then I would refund the money. This is certainly not non-refundable. It is refundable as long as they give me notice. Another reason why I do like to charge is that it does stop the no-shows. I personally find it very frustrating when somebody has set up a meeting with me and they're a no-show. And if there's no skin in the game for them, then there's a lot more incentive for them to just kind of brush it off if they change their mind. By putting a little bit of money up front, they'll remember. And I've found that my level of no-shows has gone way down since I've charged even for this initial consultation. So, for $30, my goal here is not to get rich. This is not meant, it's really not meant for me to make a lot of money off of. It's really meant just for someone to commit and take it seriously and know that my time does have some value. Now, with this 30-minute consultation, sometimes they become a client. And again, sometimes they just want to talk to a lawyer for a little while to get some feedback, to run something by a lawyer and see what a lawyer says about their situation. And if that's all they're looking for, that's great. I have no problem with that. And hopefully they're satisfied with the outcome. So let me jump back. And now I'm back in the PowerPoint, and hopefully you're looking at that now. Oh, I'm sorry. Let me, before I do that, let me go back to Calendly. I just want to show you other options. So I'm not going to fill this out and actually schedule the event, but that's how that 30-minute would work. Another option that I make available is for the client who feels like they need more than just a brief consultation. For the client that feels like they want me to review some records, they really want to dig in. So sometimes they'll schedule this initially, and sometimes this will be a follow-up. So click on that. And this, I am charging more money. This is a bigger commitment for both of us, for both the client and for me. So for this, I'm charging $275, but the same idea applies. They will choose the date and time that they want. They'll fill in the information, and again, they will pay with PayPal. So Calendly syncs up with PayPal. And then I just get a notice, out of the blue. I'll get an email saying that somebody has paid, X amount of dollars for a consultation. I'll get a notice of when the consultation is. And this is on my website. So I'm assuming that it's okay for me to be talking about this during this presentation. Evening and weekend consultation, for that one, that one basically is even, a higher amount of money, because someone is, they're asking me to give up my evenings and weekends to try and speak with them. So it doesn't happen often, but there are people who really want to speak to somebody quickly, on off hours, which is okay. But there will be they'll have to pay for that. And then I have one more option for referrals from other professionals, doctors, lawyers, educational advocates. And when they click on this, you'll see this one is free. It's a 15-minute consultation. It's really more of a professional courtesy to other professionals who are referring clients to me. And this will pretty much work the same way for scheduling, but they won't, the potential client won't have to pay anything to speak with me, but this will be more limited. This is for 15 minutes, and it's really just meant, to get to know each other, for me to learn a little bit more about their case and to see if it's something that I can help with. Because usually when they're referred from another professional, that other professional has already done the screening, and in terms of whether they really, the person really does need to speak to a lawyer. And you can be flexible. I was flexible. For instance, a few months ago, things were a little slow, so I stopped charging. I did not charge for the 30-minute consultation. I just took that option off the table. The 30-minute option was on the table, but I took away having to pay for it. Once I got busy and I realized I really don't want to be giving away 30 minutes at a time, then I started to charge for it again. What was interesting is when I stopped charging, there were some no-shows. So it does happen. I think charging a small amount of money will stop the people from being a no-show. So your fee agreement, once you've spoken with the client and you agree that, you both agree that you want to move forward together, you absolutely should be signing a fee agreement or have a letter of engagement. This is your contract, so make sure you draft it wisely. Billing is a big part of this. Be very clear in the fee agreement. I've tried to reword, I think we all start off with samples either from other lawyers or wherever we're getting our template from for a fee agreement. I've tried to make it I've tried to put it in layman's terms as much as possible, because I really do want the clients to understand what they're committing to and what I'm committing to as well. So we'll be coming back to the fee agreement a few times during this presentation. Let's talk about the type of engagement that you have and how you'll bill for that. So of course it's hourly. That's the traditional way of, oops, I'm sorry, let me go back up. Hourly is traditional. X amount of dollars, and that's what you're going to bill for.
Sorry.
X amount of dollars per hour times the number of hours. I'm sorry, does someone have a question?
Can I just chime in, Jim? Can you switch your screen share back to your PowerPoint since we're still looking at the Calendly page?
Oh, thank you for letting me know.
I know it's hard to keep track of the toggle. Thank you.
Okay, are you seeing the screen now that says type of
Perfect.
engagement?
Thank you.
All right, great, thank you. So hourly is the traditional way of doing things. You probably will collect a retainer and you'll draw down on that. Or if you don't collect a retainer, you may just bill the client each month and they will pay. Then there's flat fee billing, where it's the traditional way of doing that. Estate planning is a good example of the traditional way of doing that. You're going to charge X amount of dollars for doing something like drafting an estate plan. I actually have I've been doing this for several years now, where I do a flat fee for litigation, which it took me a long time to figure out how I could charge a flat fee for litigation. Why would I want to do that? Because when you litigate, it can get very expensive for clients. Sometimes they would be caught off guard by an invoice that was much larger than they expected. Sometimes I would discount the invoice because I just felt so bad about the amount of time that the litigation took. So you'll see what I've done is I've broken down the litigation to stages, and I charge a flat fee for each stage of the litigation, so the client will prepay it. And then there are ways that that money can be refunded depending on when the case gets resolved. And we'll go into that in more detail. So you can actually do flat fees for litigation, although it certainly is more complicated to do that. But I'll tell you that the clients, since I've started to do this, the feedback that I've received from my clients is overwhelmingly positive, that they appreciated knowing upfront what the cost would be so that they could budget for it, and so that they knew they would not get caught off guard with any invoices that were larger than they were planning for. There's contingency billing, which really is not billing until the case is pretty much resolved, where you would get your standard fee, 1/3 or 40% or whatever that might be. And then there's a hybrid. And sometimes, actually, I've got part of a hybrid built into my, when I start off with clients as well. For example, when I start off, most of my work is not litigation. Most of my work is just advocacy for clients with school districts. So I charge hourly, but for that record review, I cap the cost. So as long as the clients send me only the records that I'm asking for, and they don't overwhelm me with other records, I cap the cost at 10 hours of my time. So if it takes me more than 10 hours of time, and they've sent me only what I've asked for, then I don't bill them for any more than 10 hours. Now, if they send me a lot more than what I've asked for, then that cap does not apply. And I bill that, or I define that by the number of pages, because I know if they send me only what I've asked for, they should not be sending me any more than about 400 pages. So if they send me more than that, then I'll charge, if it takes me more than the 10 hours. You can also have another example of a hybrid is you could have contingency, but maybe the client will pay certain fees as you go along. So I talked about the flat fee for litigation. And here's an example from my fee agreement. So this is just one section of the fee agreement. And this is a fee agreement that we sign only when I'm engaging in litigation. So this is not my standard fee agreement. This is more, when things have really, we haven't been able to get resolution, and the client and I have no choice but to file for a due process hearing. So you'll see it says payment schedule. Client agrees to pay a flat fee for the above service. So in other words, I will have defined what we're doing. We're filing for a due process hearing. For the above service according to the following payment schedule. Amount due when signing this agreement. So if I've already done a record review, then there'll be a dollar value in here. Or if I've not done a record review, then I have to take that into account, and there'll be a higher amount listed right below it. Actually, let me see if I can, give me just one second. Okay, so where I'm at 1A2, the initial fee, if they have, if I've not done a record review yet. Then below that, Part B, if we have to go to what's called a settlement conference, which is kind of like a mediation, but I mean, it's a little bit more complicated than that. But there's something in special education which is available in Massachusetts called a settlement conference. It's optional. It won't always happen. But if we do decide to go to a settlement conference, then a certain amount would be due 1 week prior to that settlement conference. Same idea with what's called a pre-hearing conference. If we end up going to a pre-hearing conference, which again may or may not happen, then a certain amount would be due 1 week prior. If we have to do discovery, then a certain amount would be due prior to discovery. And then finally, if we really have to do a due process hearing, if the case has not been resolved, then at least 3 weeks prior to the due process hearing, that final payment would be due. So that way, if we get resolution early on, then they never have to give me the amounts from parts B, C, D, and E. If we get resolution at the settlement conference, they don't have to pay me parts C, D, and E. And you'll see that there are asterisks here. And basically that means that these are optional. If we don't do that, then no amount is due. So when I first started to implement this way of billing for flat fees for litigation, my refund policy was not as robust as it is now. I attended a presentation from someone from the BBO that this person presented at a starting out solo meeting. And she was very clear. The BBO frowns upon non-refundable flat fees. They don't like it when lawyers say it's a flat fee and this cannot be refunded once you pay it. And in fact, if someone pays me X amount of dollars to start the litigation and the case magically settles the next day, I cannot in good faith keep that money. in good conscience keep that money. That, it's just that wouldn't be right. So I had some refund options built in there, but then after listening to the BBO talk about this, I built far more refund options in there. And this next section is also from my fee agreement. And each part that's refundable, and just about every part is refundable, will have a subsection below it defining how it can be refunded. So you'll see here, the initial payment. It may be partially refundable as follows. Within 3 weeks of signing the fee agreement, as long as the hearing request has not yet been filed with the BSEA, that's the Bureau of Special Education Appeals, the client may request in writing that this agreement be canceled and that a partial refund be issued. The refund will be based on the following schedule if the hearing has not been if the hearing request has not yet been filed with the BSEA. So I've tried to make it as clear as possible that there can be a refund. And what are the options? Well, the first thing, if the fee agreement is canceled within 1 week of execution, then most of that money will be refunded. If it's canceled after 1 week, but within 2 weeks, then a lesser amount will be refunded. Why? Because I've spent time on it. The more time that goes along, I've almost certainly spent time on this case. If more than 2 weeks pass, but it's within 3 weeks, then a lesser amount will be refunded, and then no refund after 3 weeks of signing the agreement. And that has been very fair up to this point. Hang on 1 second. Okay. So now let's just talk in general. What is billable? If you fall asleep at your computer for an hour because you're working on a case, sorry, but that's not billable. So you want to be careful. In general, most legal activities that you engage in on behalf of the client is billable, and that should be listed in your invoice. However, you can't bill for anything that is clearly excessive. I also, let's say that I need to do legal research. I try and be reasonable. If it's something that I feel I should have known, or that, it's really not a novel issue that I'm researching. I'm researching something that is just, I'm thinking, I know I've run into this before, and I can't remember what the case law is, or I can't remember what this statute or regulation is. I don't charge for that kind of legal research. That it's not the client's fault that I can't remember what the case law or statute or regulation is. So they shouldn't have to pay for that. That's my personal way of thinking about this. But emails with the client, drafting memos to the client or on behalf of the client, phone calls with the client, meetings, hearings, settlement conferences, talking to opposing counsel, that's all billable. So certainly that I track that as best I can, and the client will see that on the invoice. I do differentiate between, hang on. I do differentiate on my invoice between attorney, paralegal, and travel rates. So most of the work that I do, of course, is billed at the attorney rate. If I do something at, that I feel doesn't really require legal training, for example, the client sends me 400 pages of records, and I try and keep as electronic of an office as possible. I scan everything in. I OCR everything, optical character recognition, so that I can so that I can search for keywords and quickly find a document that might be important. So scanning in documents, that doesn't require legal training. There was no class I took in law school for how to scan documents. So for that, I'll track that, and the client will see that on the invoice, scanning time. But I'll bill that at a much lower rate, at a paralegal rate. And likewise, I don't charge my full rate for traveling. So if I have to drive somewhere to go to a meeting, they'll see something billed at what I call the travel rate. It's a much lesser rate. So The rule of professional conduct in Massachusetts is very clear that you cannot bill for anything that is what they call clearly excessive. And if you go to the Mass Rule of Professional Conduct 1.5a, you'll see that this is a copy, or this is what 1.5a says. The factors to be considered in determining whether a fee is clearly excessive include the following: the amount of time and labor that's required, how novel and difficult is the question that you're dealing with, how much skill is required to perform that. So, and that's why if I'm dealing with something which I know I should know the answer to, but I have to research that, that's not novel. That's me just not being able to remember. So I don't bill for that. That would be clearly excessive in my mind, to bill a client for things that I really should know. The likelihood, if apparent to the client, that the acceptance of employment, in other words, if I'm going to, to do some work for a client, does that preclude employment, other employment by me? Do I have to turn down another case in order to work with this client? The fee customarily charged. So, there it's just knowing your where you are, what other attorneys are charging, and I don't know if attorneys really talk that much about their fees. Some do. The attorneys that I speak with in my circle of special ed attorneys, we don't blab it to each other, but sometimes we'll talk about what our hourly rate is. The amount involved and the results obtained. So I don't have to read this entire thing, but if you go to the Mass Rule of Professional Conduct, you'll see what is defined as being clearly excessive. In my fee agreement, there's a section called time charges, and I lay out everything that I could think of that I might bill for. And but I'm also very clear. The time charges include, but are not limited to. So, there may be more. This is not necessarily all comprehensive, all encompassing, but generally telephone calls, reading and responding to emails, drafting emails, court appearances, including the Bureau of Special Ed Appeals, which technically is not court, but that's where hearings take place, team meetings at schools, travel time, office conferences, legal research, depositions, reviewing materials, all of that. So I tried to think of everything that I do on behalf of clients, and I put it in here. And I also told them I bill in increments of 1/10 of an hour. So how do you track your time? How do I track my time? There are multiple ways of doing it. There's the high-tech way, the low-tech way, and the no-tech way. It doesn't matter how you do it as long as you do it. I started out with no tech. I just kept a time tracking sheet that I wrote down the starting time and ending time, and generally what I did and who the client was. And I'll show you that in just a moment. Currently, I use Zola Suite, which is through the Social Law Library. Actually, my subscription to Zola Suite is through the Social Law Library because it's free if you have a Social Law Library membership. You can also subscribe just to Zola Suite if you want, but there are other competing products out there. There's Cosmolex and Clio, MyCase, Rocket Matter, and others. So there are a lot to choose from. And you should track your time. Even if you do flat fees, you should still track your time. Because if you ever have to, let's say that you ever have to back up whether your fee that you charged for a flat fee is reasonable, part of that is probably going to be showing what time you spent on the case. So the client may not necessarily see that individually time, the time breakdown with each invoice, or through a monthly invoice as the matter moves along if it's flat fee. But nonetheless, you should have backup for what you did, so you can prove that your time was reasonable. So this is a practice management dashboard from MyCase. And again, MyCase was one of those practice management tools that I just talked about. I think they're all fairly similar. So Zola Suite that I use, this looks very familiar to me because Zola Suite is broken down fairly, similarly to this. You can click on calendar and see your calendar. You can click on tasks and see the tasks. This option right here is the billing tab within my case. So if you click on billing, you can add an invoice. Let me click on the laser pointer again. You can add an invoice. You can record a payment that the client made. You can deposit money into trust. You can request money from the client. So there are lots of different options that concern money, billing, or receiving payment. You can get a quick overview of your trust account here. In the invoice overview, how much is due that you haven't billed for yet? How much is due that you have sent? How much is overdue? All right, so this is kind of your dashboard. When you use a practice management tool, there are timers that you can use. This is a huge help. So you don't have to write down the starting and ending time. You can just click a button. So, oops. I'm sorry, hang on one moment. So you could click on this arrow here. It's almost like like a VCR. You just click the button and it starts to run. You select which matter it is because you will have already defined the client within this software. The date is probably pre-filled. What type of work is it? Is it billable work or not? And then a description. You would type it in. This description that you type in here is what will end up on your invoice. So, as the day goes along and the days, the hours turn into days and the days turn into weeks, at the end of the month, when you go to do your billing, all of these things get combined for each client and they just show up on the invoice. And it's almost like magic. It really is a huge time saver. So this is an example from Clio. Here's an example from my case. Also, you can have multiple timers running at the same time. And if you're jumping back and forth from one client to another, you just keep clicking the button and the time just keeps incrementing for that particular client and it automatically stops for the other client. Because you can probably only deal with one client at a time for billable matters, for billable time. And this is just a close-up to see it a little bit better, what that time tracker looks like. So with practice management software, they're very helpful. I find them very helpful for certain tasks like tracking time and invoicing. Invoicing is pretty much just clicking a few buttons at the end of the month and the invoice is created and you send it out. It literally has saved me, I would say, on average, about 1 day per month of invoicing since I started to use the practice management software. It's just so much easier than before I used it. What I use, Zola, has replaced QuickBooks. I don't have to have QuickBooks anymore for my accounting. I can run reports very easily. So if I want to see a profit and loss, like I don't know how many people have applied for those PPP loans, but part of that, when you apply through the bank, is they want to see a profit and loss, or I need to be able to at least show them what my profit was. So that reporting is very easy, and that's kind of those last two bullets there in that first box. Now, there are things that I find questionable. Technically, there's a lot more that these practice management tools can do than what I use it for. Exchanging files with clients. So yes, you can, in a secure format, upload files, download files, make files available to clients, have them upload files to me. The feedback I've received from clients is they find the interface too confusing. Unless the client is technical to begin with, they've struggled with it. I don't find it worthwhile. I can share files through Dropbox that I use. It's very easy to share files through Dropbox. You can share them through Google or OneDrive. Email. Most of these tools have their own email system built in. I don't like it. I'm used to Gmail. I don't want to give that up. I like the way Gmail has their folders built in. I'm used to it. I don't want to give up Gmail at this point, so I don't use these for email. Same idea with calendaring. I use Google Calendar. I don't want to give that up, so I don't use the practice management tool for that. And same idea for tasks. You should be forewarned. Sometimes these tools seem like they're not quite ready for prime time. I've had bugs that have been really annoying. With Zola Suite a couple of years ago, it had a bug with their time tracker. And I was pulling my hair out. I was so frustrated because I would spend 2 hours on something and I would go back to stop the timer and I would see that the timer never really even started. I thought it did, but it didn't. Or if it did start, I know that I had been working on something for, let's say, 2 hours, and it was only giving me credit for, like 10 minutes. So I ended up having to track my time manually anyway until they fixed that bug. And honestly, Zola was a little frustrating to deal with. They, at first really wouldn't even admit there was a problem. They were kind of slow in fixing it. Finally, it was fixed, but it was frustrating when that was happening. I also find that sometimes they'll make changes or remove features without even warning me, out of the blue, things that I had been using, which, features that I thought were fantastic, just all of a sudden disappeared. And when I would call tech support to find out, where's that feature? What happened to it? Oh yeah, that got removed. So that's frustrating. Be careful when you commit to a practice management tool. They're proprietary. It's not like the data at the time that you've entered in Zola can be used by MyCase or by Clio. So you want to think about how accessible your data is. Can you export the data and make it available for importing into another tool? Or are you going to have to spend a lot of time re-entering data, time, for example, that you've already entered? If I switch from Zola to Clio at this point, it's going to be a very difficult, painful switch, I think. I initially started out with Cosmolex, which that's also a practice management tool, and then eventually I switched to Zola for reasons that I don't have to go into right now. But it was a very difficult switch. I had to re-enter time for basically about a year. So it took a lot of time so that I didn't lose everything that I had already entered. There are low-tech options and no-tech options. So low-tech is, you could create a Google spreadsheet and track it yourself. So for example, this is the way I used to do it before I started to use Zola Suite. And let me share this with you. So you should see my Google spreadsheet here. And this is, I just wrote this myself. This is, nothing professional. And you can see, the columns that are here. So I would put a date in. So let's say it's March 11th. And hopefully you're seeing me entering this. If you're not seeing me entering it, please let me know. Put in the start time. So maybe I started at 4 p.m. And then you put in the end time. Maybe I'm starting, let's see, I'm stopping this at 4:51 p.m. So you enter what it is. Then these are these next columns, or some of the next columns are calculations or formulas. So I don't know how comfortable or familiar people are with formulas, but basically what I've done is I subtract the starting time from the ending time, and it tells me how many minutes I've spent on the case. Who do I want to bill it to? you put in the client name. And then in tenths of an hour, how much time have I spent? Well, I've spent 0.9 hours, and I'm going to bill for 0.9 hours. And then times an hourly rate. This is predefined hourly rate. 0.9 hours will work out to $2.25. I think the hourly rate that's there is $2.50 is the default. Or if I want to do this at paralegal time, I put in a P, and you can see that that changes to $112.50. Or if it's travel time, put in a T, and it's a lower rate. So this is all up here at the top. And it looks a little complicated, and it took me a little while to figure out how to do this. And I'm not, I don't think I need to go into the details of the formula right now. And hopefully, since this is being recorded, you'll be able to see this in the future if you ever need to access it. So anyway, that's the formulas that are in there, and that's it. I would keep entering information, literally minute by minute, hour by hour. At the end of the month, I could sort this by client, by date, by starting time, and eventually this would become the basis for my invoices. But it's more manual, so it takes more time. And let me go back. So you should see me back in the PowerPoint presentation at this point.
Yes.
Whoops, it would help if I were there. Okay. And then of course there are the no-tech options. This is just a piece of paper. You can write down the task, the start time, the end time, total time that you've spent on it, and eventually this will become the basis for your invoicing. As far as the invoices, be as detailed as possible. Clients want to see what they're paying you for. Don't just have a monthly invoice with how much is due, and have a summary of legal fees, legal services rendered. It really should be better than that. So, you'll see what I've entered in ZolaSuite. This invoice is actually printed out from ZolaSuite, and it did not take very much work at all. As I said before, just a few clicks, and the invoice is created. And you see that it's broken down. Sometimes there are multiple entries per day. Because remember, each of those entries that I entered becomes a line item on the invoice. And you can edit this before you finalize the invoice. And you can see what the quantity is, what the hourly rate is. Sometimes you may want to discount something. So there are a few things that I said, well, I don't want to bill a client for that work, but I want them to at least see that I did it. And I want them to appreciate that I'm not charging them for it. So I put in 100% discount for those particular things. And then line item by line item, what's the total? And at the end, this goes on to a second page. There's a summary, a subtotal rather, and a total. So for me, this is where practice management really shines, because as I said, this saves me at least a day a month. So for what I'm paying for the social law library, being able to use ZolaSuite, I think is well worthwhile. And I know we're starting to run tight on time here, so I'll try and move it along a little faster. How to get paid. My hourly agreement requires payment within 2 weeks. So they can pay either by personal check or credit card. And here's what my fee agreement says. The client agrees to keep a valid credit card number on file with me. And the client agrees that when the invoice is received, they'll pay within 2 weeks, either by sending in a check or by paying with a credit card. Or I can use the credit card that's on file. So that's what this section is saying. It's just the client is committing to paying within 2 weeks once I send that invoice. Should you take credit cards? I do. And I think the answer for most attorneys should be yes. It, if you've ever read Jay Thunberg, How to Start and Build a Law Practice, for me, that was my Bible when I first started to practice. He's very clear in there that accepting credit cards is a good thing. You should do it. It saves you from having to chase down clients. It saves you from, having clients say, "Oh, I'll send in the payment next month," or, "Oh, can I send in half this month and half next month?" Or, "Can we create a payment plan?" You know, Basically, if if they ask, "Can you do a payment plan?" The answer is yes. You can charge it to your credit card. That's the payment plan. I don't say it quite that crassly, but that's that's what it's for. The client can they pay the credit card, and then they can deal with their credit card, for payment. Yes, there is a fee, but for the 2 to 3% that the credit card is charging, it's worth it to get 97% with no questions asked, no fighting, no problems. It's just part of the cost of doing business. Should you pass along that fee? That is not a good idea. You should not do that. Basically, you should eat that 2 or 3% and be happy that you're getting 97 or 98% of the amount that's due. Mass General Law, Chapter 140D, Section 28A, states that no seller in any sales transaction may impose a surcharge on a cardholder who elects to use a credit card in lieu of payment by cash, check, or similar means. So you really, is this a sale? Well, I'm not going to get into a UCC discussion, so it may not technically be a sale, but I think that you should consider this, you should think along these lines. Don't impose a surcharge to the client. Do you want a discount, for somebody who doesn't use a credit card, pays by check? Maybe. I mean, that may be something you can consider. The BBO, if you look at this article that's on the BBO website, and the link is here, they state most lawyers, as a matter of good client relations, will undoubtedly decide to absorb the discount, meaning, you're only getting 97% of the client fee. You basically be happy that you're getting that, and you don't have to go chasing the client. So you can use credit cards to charge the amount that's due each month. You can use credit cards. Technically, you can use credit cards to fund IOLTA, the retainer. I don't. I do not accept credit cards for that, and you need to be very careful with that. You can use LawPay to fund, for retainers for IOLTA. The problem with using credit cards for IOLTA is you're only getting 97%. So immediately, the client is, or you're going to have a 3% shortfall in your IOLTA, and that's not a good way to start. LawPay will charge that 3% to your operating account rather than to IOLTA, so that's why they can do that. But what if there's a chargeback? What if the client disputes that charge? It's just, you're getting into something that I think is a little dangerous. I don't like it. However, I do keep the credit card number on file. And it's up to you whether you feel comfortable doing that or not. Some attorneys do, some attorneys don't. I'm okay with it. I mean, I try and protect it. I make sure that every credit card number I have electronically is encrypted. But by keeping it on file, it allows me to bill to bill a credit card for the client each month. So the way I use the retainer is, or the traditional way of using a retainer. The client fills it, you bill against it, you withdraw from it, and eventually the client has to replenish it. And you go through the process again and again and again. It's a cycle. The clients don't like it, and I don't like it, in terms of having to ask them to replenish that retainer. And you have to ask for a fairly large retainer because you don't want to be replenishing it every month. What I do is I treat the retainer more like a well, basically, I treat it more like a security deposit. I forgot the phrase, but I treat it more like a security deposit. So I hopefully don't bill against that retainer. I keep it there just in case it's needed, So I take a much smaller retainer than I used to do. It goes into IOLTA, and hopefully I don't touch it. I bill a client each month, and the client hopefully pays me each month. They either send in a check or they pay by credit card. I would only bill against the retainer that they've given me if I tried to bill against their credit card, that credit card was rejected. I contacted the client and they just basically don't make good on it. So something's going wrong anyway. But at that point, because it's already been defined that I have the right to do it, I would bill against the credit card. Honestly, I've never had to do this since I have been doing this, which is now several years. At the end of the engagement, assuming I have not needed that retainer for any reason, it will be returned to the client in full or would be applied against their final invoice. And here's the section of the fee agreement that authorizes me to, or that defines how I'm using that retainer. And I'm very clear. The retainer will be used in one of two ways. And it's just as I defined a moment ago. So everything I just said is in this section 2 of my fee agreement. What if there's a dispute? Be reasonable. Work with the client. It's not worth getting an angry client over a few dollars. So if there's something that's even slightly questionable, give it back to them. Don't just give in immediately. You should be able to defend why you charged what you charged. But if there's, so be reasonable. But if it's questionable, err on the side of caution, and you can refund some or all of that, whatever is in question, if it makes sense. I'm not saying, I'm not saying just to give in quickly, but hopefully it doesn't escalate. You don't want this to escalate if there's a dispute, because if it does, guess what's going to happen? You're going to end up with a BBO complaint or a malpractice claim or a negative online review. And those are all really bad things to have to deal with. And in my fee agreement, this is the paragraph that deals with disputes. If the client disagrees with any fee or expense, the client agrees to notify me. I want to know about it. Tell me right up front that there's a problem. And we agree to work in good faith to get that issue resolved. If the dispute raised cannot be resolved, if we can't reach agreement, then we're agreeing to go to arbitration with the Mass Bar, or since I practice in New Hampshire, with the New Hampshire Bar, or some other fee dispute resolution body, and we agree to be bound by that, not go to court. I've gone to mediation or arbitration once with the Mass Bar Association, and this is where I learned that it's not worth it. For the amount of money that was involved, it wasn't worth it. Let me phrase it that way. If it's a large amount of money, then maybe it is. But with the amount of time that it took to prepare for the arbitration, to go back over my time and make sure that every single line item really could be defended, in the end, I did, it worked out fine. Let's just say it that way, right? Financially, it worked out fine for me. I was satisfied, but I was not satisfied with the amount of time that it took. It took away, from my being able to practice law for other clients. So, in hindsight, I probably should have just refunded whatever the dispute was and not dealt with it. And that is it. So, at this point, why don't we open it up to any questions that people may have?
Okay. So, James, I've only got one question so far in the chat. And of course, I just remind everyone to feel free to continue to submit questions by chat, or to feel free to unmute themselves or raise their hands at this point. Just to relay the one question that we have in chat, it is, and I'll just read directly, are attorneys allowed to use PayPal? I thought there were only specific point of sale vendors we could use, like LawPay. I do also want to note that I'll share a webinar on demand that we have from MassLoMap in the chat with everyone about electronic payments, but thought you might be able to also provide an answer, James. Thank you.
Sure. So yes, you can use any credit card vendor or processor that you want. So there's Square, there's PayPal. I think Stripe is another one. You can use anyone that you want. I think the issue that you might be thinking of is what I talked about earlier with IOLTA, that I certainly would not fund a retainer in IOLTA with PayPal because of the issues that I talked about previously. Whereas LawPay that's the one vendor that I'm aware of that is safe to use for funding the retainer, for funding IOLTA. So that might be what you're thinking of.
Great answer, James. Thank you. And welcome that person to ask any follow-up questions in the chat along with anyone else. And I'll just keep an eye on that for another minute. In the meantime, I still haven't seen anything else come in. So I just, again, want to thank you for such a thorough presentation, James. Really excellent.
You're welcome. Thank you all for your time. It was a pleasure doing this for you.
All right, great. Well, since you've got your contact info there, I'll leave anyone to grab that in case they have any questions kind of emerge over time. And of course, you can all feel free to contact us at MassLoMap. And yeah, with that, I'll just say goodbye to everyone. Thank you so much, James. It was a great presentation. I hope you all have a great evening.
Thanks very much. Have a good night.
All right, bye.